Welcome everyone who is here with us live or watching from the streaming platforms from the recording. This is the third and last one of our Sparring's Decoding Legal session. This one will be about launching your product. This is a part of a three-part series or legal essentials for Cardano founders. You can find the previous sessions on YouTube, on our YouTube Sparring Law channel, or from any of the Cardano network platforms. Without further ado, I think we can start this. This is the third of our sessions, and so you probably know what is it about and are here to get some information. So this is the overview of what we will tackle today. I'm not sure, Matthew, whether you want to start this part or whether this is still on me.
Of course, happy to introduce the topic today. So in the previous webinars, we focused on finding the right place to start your entity, dealing with the initial regulation, and then setting up the internal relationship within your team, possibly looking at fundraising. Today, we'll cover the external parts, relationships with your customers, and more of the documentation that you might need just after you launch your platform. We'll cover the launch terms, AML, KYC, data protection policies. Then we'll move to specific types of Web3 startups that you could be dealing with, and the specific niche documents or processes that you'll need to cover there. And then in the end, we'll dig into a few sort of specific case studies, lessons learned from the projects that we worked with, which might not be immediately obvious, but could help you avoid some real issues down the line. And so with that, we'll focus right away on the product launch and the policies that you might need in the beginning. So the absolute first thing that you will need to deal with when you're launching any kind of product, and just when we talk about product, try to imagine anything from a staking solution, a DeFi protocol with its own sort of web UX, or this could be a service where you're providing consulting or SaaS services within the Web3 ecosystem, so really almost anything. So the absolutely first thing that you'll have to think about are the terms and conditions or the usage terms with your customers, because this is the legally binding contract that ensures that your customers have to pay for your services. It regulates the liability, it regulates user access, and it covers all sorts of important contractual matters that you should have covered when you're dealing with your customers. There's of course a lot that you need to cover in your terms, and I think that you'd be familiar with most of this with interacting with either on-chain or just off-chain non-Web3 terms elsewhere. But the few sort of niche specific things that you should think about when you're dealing with a Web3 product would be, first of all, user access. Very often, you'll be thinking about which countries or which types of users can access your product because it could be regulated elsewhere. Terms are the place where you include this. Second would be the risk disclosures that your users should think about. So, for example, if it involves any sort of trading, any derivative contracts, anything that carries with it some level of financial risk, for example, it's very good to include those for your own protection. And then, of course, thirdly, dispute resolution. Given that your team and your clientele could be, well, spread all over the world, it can be really difficult to track them, figure out where the services are provided. It's quite important to figure out how any disputes will be resolved, who should be contacted, and in the worst case, which courts you will go to. And of course, there's a factor of usability as well. You can include like essentially classic text contractual terms, but you can make this a bit more user friendly as well. And then passing on to Andrej for privacy policy.
Oh, I'm muted, sorry. Yes, so the privacy policy and cookie and tracking notices are usually a necessity not for your product per se, but for compliance reasons. It is, from my point of view, easy legal low-hanging fruit, as you can usually outsource preparing this documentation. It's very common throughout the world now, and you generally each continent or each country have their own data protection rules. There is GDPR in the Europe, which is usually the highest standard of all the data protection regulations. Then there's CCPA in the USA. Asia is slowly rolling in, with frontrunners being Korea and Japan. And it is usually I will tackle this a little bit further later on, but you should always have in mind that these documents should be prepared when you are launching your product for public, as the rules usually apply from the day one. Maciej, go ahead for the last.
And then add in a small disclaimer on disclaimers. So generally, if you're dealing with smart contracts or anything that would involve investment risks, it's always very good to state this and provide this as a disclosure to your customers. First of all, for your legal protection, and second of all, just to help and educate the ecosystem. If you have a nice disclaimer that is very user-friendly, shows people what the risks are, what they should be careful about, it not only protects you, but makes the experience for your users a bit better. So it's everything that we're talking about is, of course, the legal work to cover you and protect you from liability, but it can also actually improve the UX of your users. So it's good to perceive it from that way as well.
Maybe I'll add on the privacy and data protection here, as I realize that we have no more the slides there. So yeah, but what you should focus on once you are dealing with data protection. So it is actually, the main point is what data you collect. It can be like wallet addresses, emails, device IDs, anything really. Then you should focus on why you collect it. These principles I'm talking about now are generally applicable across all jurisdictions. It is just the level to which the certain countries provide protection to users. That is the difference between the countries. So there is what data you collect, why you collect it, how long do you keep it. Then there is user rights. The fourth point, that is access, deletion, correction, so on. And the last one is cross-border transfers. So this is what you generally should have in mind. I tend to call this a drawer documentation, meaning like you prepare it and you paste it on your website, and like it's something like you put on a drawer and in a drawer and never use it anymore. But it is there on the website, and so you have this checked, and it is really something that is like a low-hanging fruit, as I said. Yeah, go ahead, Maciej, sorry.
And a note here that maybe isn't too obvious, like you usually need to deal with data protection even if you're not collecting your users' names, for example. Even if your users are anonymous, you might be looking at their IP addresses, their emails or usernames. That could be something that you're still tracking, and therefore you will probably need some sort of a data protection policy. So do be careful about this, even for anonymous projects. So then looking at a few sort of very specific regulated features, if any of this is something that could concern your product, it's good to include it in your terms of service or to have this as a sort of separate disclaimer or document. So whenever you're dealing with any deposits, custody, or staking, it's very, very important to have the rules here clarified to the maximum extent possible. Explain which entity is doing the custody or the deposits, whether they are doing it as a service provider or they are just subcontracted under you and you are the primary service provider. It's very important to clarify the legal rights and the relationships here, just so your users understand who they should look to if there's any issue. Your users understand who's responsible for their funds, and generally everybody's on the same page with regards to responsibility. Of course, same goes for risk of loss or irreversible transfers, any smart contract execution. It's good to know for your users to understand what the risks are, what could happen, and if something happens, who they should turn to, what the email address that can provide them with some support and responses. And this might seem unnecessary for many products, but do trust me when I say that you never expect trouble to come in. And if there's a dissatisfied user and you don't have a clear rule for who they should contact, who's doing the support, what their rights are, which entity is responsible, that user can become more and more frustrated and cause you a lot more risk and a lot more issues down the line. So it's good if they know what to do, who's responsible, and how they can deal with them. And then of course, you should include anything jurisdiction specific. If you're doing a product that is regulated in one country but not in another, it's good to say that these are the countries where some special rules apply, for example. That could apply to my kind EU right now, or some securities disclosures in the US, for example. And of course, same goes for tax responsibility. Nobody's happy to get a tax bill that they didn't expect. So it's good to make sure that your users understand that what they're doing on your platform or with your product could lead to some tax liability for them. They could make profits which are taxable. Is their responsibility to deal with this? And if you want to, you can provide some resources here to just make sure that your users really know what they are doing. And moving on to AML for Andrej.
So AML KYC, probably you've heard of it. AML is anti-money laundering rules or frameworks, or as you can call it. And KYC is know your customer. The KYC is also used for, or you might also heard of KYB, which is know your business, and it is in B2B relations. So to tackle this generally, these rules apply usually country specific, meaning each of the country implement their own AML KYC rules. So first you should look in the country where you want to operate from, as that is you have the highest exposure in this country. But there are some general rules, those apply. So the first thing with the AML and KYC is an organization, an intergovernmental organization that is called FATF. You probably heard of it. It's the Financial Action Task Force. It is an organization that was founded like 35 years ago. Currently, it has 40 states, 40 member states, and it creates the guidelines. Those are a baseline for each country's AML and KYC frameworks. And these guidelines, if you read through them, they set a base for these for the particular obligations that you might have in connection with AML and KYC. So you always, and these guidelines are not applicable against businesses per se, but it is applicable based on the activities they provide. So you first must check whether these rules or your internal country rules apply against you. It depends on what services you offer. For example, exchanges, wallets, fiat bridges, the custodians, we have it named here, usually have AML and KYC procedures applicable, meaning you must do some customer identification and source of funds verification, for example. But these these obligations might not be applicable for you, for example, if you don't touch the funds of your customers, meaning you provide, for example, non-custodial wallets. In that case, you are not a virtual asset service provider under FATF rules. But still, if you provide some special services, it might apply to you. So always you should these rules are very, like, I would say, serious from a legal point in comparison to privacy policy, for example, as these might trigger, for example, criminal liability if you are not complying with these. And so you should always do your research when doing AML and KYC. A rule of thumb for me, as I know you probably are a lot of founders that are not later stage projects. You should ask or push your lawyer and argue with them whether the AML and KYC rules apply for your project. But if you ask, for example, ChatGPT, don't push them, because usually ask like for their general idea when you are doing your basic research, because like if you push too hard, they will the ChatGPT will try to say like, okay, this is fine, but then it might not be. So push your lawyer, but not ChatGPT if you want to have your very first idea whether it's applicable for you or not.
Maybe just a sort of tiny side note here to add in a very practical point. Determining AML KYC necessity is complicated, but the good rule of thumb is think about whether someone could use your project to fund illicit activity or a terrorist group, for example. Is there any way anyone could use your project to funnel cash or crypto assets to someone who might be doing something that's probably not too legal? And this is not 100% rule, but it's just good to perceive it from this way. It makes it a bit more real for you when you're considering AML.
Exactly. Thanks. And if you there's also a risk-based approach, meaning there are several tiers of the for example KYC obligations. So the basic usually is the verification of a wallet and its owner, or some email verification. But then if you are transferring more funds, then there might be document identification, a liveness check, proof of address, and so on and so forth. With the AML obligations, there are also more tiers, and the higher tiers include transaction monitoring, watch for structures, some mixers, for example, such crypto services, or watch for any anomalies in the trading that you provide, for example. And then there are obligations like filing suspicious activity reports. There are several layers, but once you should do a KYC and AML procedures, you should contact some professionals. If you do not do this in-house, this is a service often outsourced, and that is also a good way to go to have some professionals help you. This is getting pretty standardized. So either you can onboard a third-party service for any particular part of the onboarding process, for example, or you can also get an AML and KYC solution for everything. Meaning, if you are doing trading, they will prepare you a whole documentation that you need to have for compliance purposes. This is also often offered by law firms as us, for example. If you could move a slide, please. Yes, and these are the common misconceptions. So we're decentralized, so we don't need to comply. First advice, when you are considering that this is applicable to you, you should establish a business entity and not provide your services personally, because this is usually a misconception that is not applicable. Because whether you have AML or KYC obligations is tied not to you, whether it's you as an individual or as an entity, but it depends on what service you provide. So it might be applicable to you even if you are a decentralized service, such as DEX, for example. Because if you, as a developer or an entity that is running some DEX, you might need to be in compliance with AML and KYC rules. So once the regulator or the financial authority finds that you are behind the protocol, for example, they will go after you, and you would have to prove how you are in compliance with these rules. Another one is users are anonymous, so we are safe. And that, again, is not the case, because the obligation is tied to the service you provide, and from that it is tied to you. So if you don't do the AML and KYC procedures, you might be liable, even though you say that you don't know who your counterparties are. You should know in that case. And the last one is KYC ruins UX. And I must say that partly it is true. And so to mitigate this, you should find a good third party. So if you don't do it in-house and you don't cover your whole UX experience, then you can onboard a third party service that is that is very like smooth to operate and easy to adopt for the users. And that's it. Oh yeah. So about the toolkit, about the risk-based approach, I've already spoke, and this is some users that some third-party services that we and our clients are using that can help you incorporate or get in compliance with the AML rules while still providing good user experience. As these are, you can do either you can do the onboarding, which is the KYC part usually, where you have to identify your counterparties, or you can do the on-chain analytics, that is more like AML part, when there is some fraud going on and there are some blocked wallets by the national or the states, for example, which are on the blacklist. You can check with some online tool whether this is applicable to you or not, and which wallets, for example, you should avoid. And that's also tied to transaction monitoring, which you should be doing internally if these rules apply to you only. And internal policies, as I said, you should if the rules apply to you, you definitely should have internal policies how to tackle the obligations, how you deal with requests, for example, from financial authorities, whether you have your AML officer and so on and so forth. But with these, once it is applicable to you, you should explore this further and either get a third-party service or delve deeper into the topic and do this in-house. And Majo, you may continue.
Brilliant. So moving on to a few sort of very project-specific policies that you can also think about. Some of these wouldn't be external, but will work within your team. So first of all, a good code of conduct. So far what we've experienced is that if you're running a DAO or a Discord community or any other project where there's a lot of user involvement, there's a lot of communication, whether that is within your team or outside with your users, it's very good to have clear rules for how everybody's supposed to behave and what their responsibilities are. And I didn't just mean, be nice to each other, avoid harassment, which is of course important as well, but it also means sort of deeper, closer rules for your project on who's responsible for what type of communication, who you can turn to if you think that there's some suspicious activity going on, what are the sort of the rules for communication within your Discord channels. And some of this might seem like unnecessary administration for you, and it could be if you're treating it just as paperwork. But if you do this well, it can really let your team discuss the important things about running your project. It gives your team the space to discuss what you expect from your users, what the general approach to your community should be, and how you expect people to behave. And this can sometimes show, and we've had this experience in the past, that when people discuss this, or when we as lawyers sometimes gently nudge them to discuss this, they figure out that they don't have a common understanding. And one of the founders has a very different vision for their community compared to the other one. And of course, this isn't great, and this can cause some actual issues and just friction in how they operate. So it's very good to sit down, talk this through. Generally, this is the type of document that you wouldn't even need a lawyer to write up if you're very early stage, but it's at least just having this written nicely in a human language, shared with your users, with your moderators, with anyone relevant on the team, can be quite helpful and can make your community just generally a more pleasant place to exist, and which is great for user engagement. Then second would be related to IP assignments or intellectual property or any contribution guidelines. Do make sure that if your project is doing any kind of community created intellectual property, that there's some clear rules for what your users have to accept and be bound by on who owns what intellectual property. You never want to get into a situation where you're sort of community developing a project, but you're doing 80-90% of the work, but there's some community engagement. And then suddenly when you get some user ideas, you work with them, all great, you develop your product, you want to launch, and suddenly users come in and say that, hey, I advise you on this. This is my idea. I want a 20% stake in your project, because I can guarantee you that everybody always sees their contributions as more important than they actually were. And this is, I don't mean this, negatively against anyone, but we all try, perceive ourselves as doing a great job. And so if you do not have a clear policy for example, user feedback still being your property and part of the project's IP, you could run into a situation where helpful community, getting some tips and feedback from your users could cut that into the users requesting that they own a bit of the product, and then of course of the profits that you wanted to make, or try to block your product from going live because they think that they have a claim. So do make sure that this is nicely clarified before you take in any intellectual property, ideas, feedback created, generated by your community or contributors. And this applies even if you want to go open source, which is, of course, usually the norm in Web3 projects. Even if you're open sourcing, you want to make sure that everybody assigns their intellectual property to you, and you can then, or your entity can then open source it. And this way, no one can say that, hey, this is my idea. I don't want this to be shared. I don't want this to be open sourced in this and that way. I maybe want to profit from it. So it's very good to have this covered for any type of project. And then thirdly, if you're doing a sort of a hybrid form of organization, meaning that you have a bit of an off-chain presence as well, you have maybe a bit more substantial team that's actually working on like development, and it's a bit more sort of in the real world rather than just mostly on-chain, then it's very good to have some clear, whether that's sort of human resources or contractor policies, just for people to understand what they should do, what their rules are, what their reporting is. And this is something that you might not think about in the beginning, but we've had quite a few cases where the project sort of started developing, the team was growing, everybody was happy. They decided that each will invoice, an X amount based on sort of their seniority, their role. And then a few months down the line, they sort of found out that people are just sending in invoices for the same amount, even though some of them like took 3 weeks off, they weren't there during the month, or they did no real work. There's no way for giving people feedback that will be sort of in any way structured. There's no one with authority to say that, hey, look, you're not doing a great job. Your invoice should be half of what you're sending us, or if you're not invoicing, just whatever we send to your account. So do make sure that this is clarified and everybody understands what the expectations are. So, and moving on to the sort of specific startup or business models that you could encounter, and the sort of the various specifics for each of them. So first of all, DAOs. It's one of the most common ways in which many of the projects that we work with are run. It is definitely exciting in so many ways, in how we can, foster a community engagement, how it becomes a lot more democratic than most sort of standard projects. However, they of course carry some quite unique risks and things that you should think about, which wouldn't be common for sort of a more standard project. So first of all, any kind of unincorporated structure carries legal risk. If you're a community of people developing something together, you don't have any legal entity, you just, all of your governance and relationships are on-chain, somehow has to be responsible. Someone has to be responsible somehow. There's always some form of responsibility going after someone. If there's a problem, if you breach someone's intellectual property, or if you cause someone harm, or you breach some sort of regulation, and someone starts looking into this, whether it's a user or a regulator, they will be looking for someone to hold liable. So do make sure that if you're actually starting to provide services, you're interacting with people, there's some form of money involved. And under money, I mean, any form of cryptocurrency that already has some sort of a value. It's good to have a legal entity and be properly covered. Then the second point, though, legal entities or legal wrappers for your DAOs are great, but the protection isn't absolute. You're always responsible for your actions. So it doesn't matter that you're doing it as an officer or director or a contractor of a legal entity, and even your contract with the entity has a significant limitation of liability in it. If you do something that is wrong, that is illegal, breaches regulations, or is possibly fraudulent, you can be, and you will likely be held responsible if someone looks into this. So legal wrappers, entities, and contracts are great, but they don't protect you from the misconduct that you do, and the bad and punishable things that you do as yourself as an individual. And then, of course, we can get into a bit more details on the general DAO setup. Usually, the number one thing that we see as going wrong is set up in the voting and governance structure. First of all, you need to comply with some sort of generally accepted governance standards. We are actually working on governance documents for Cardano, so those will be available. You can take that as an inspiration. But just going to large established DAOs that have good track record, it's good to see what their governance is like and take it as an inspiration for something that works. And pairing this with the last point I have here, I should have reordered them, is that it's great to have great member participation democracy, but do make sure that you are protected from any form of sort of hostile takeover or any kind of, one of those events where people take in, buy your tokens, try to vote through things which could be damaging to your community in the long term. Just do be prepared to be resilient in case of any drops in value of your governance token, because that can cause you a lot of issues. And then sort of a final point here is that if you're operating a treasury, do understand what kind of AML rules apply, what are the tax responsibilities here. Just as soon as you're handling larger amount of money in your treasury, do be careful, because there's probably some sort of regulation that applies. Andrej covered this nicely with AML. I'll talk a bit about tax and some of my practical examples. So it's very good to think about all of the possibilities of what you should think about.
Another topic is NFT marketplaces, which is fairly standard in crypto world. Usually NFT marketplaces or NFTs as such are exempted from the crypto regulation, but it varies again from the jurisdiction to jurisdiction. For example, in Europe, they have a MiCA regulation, which is widely applicable and now being a leading regulation for crypto services. But here, for example, the NFTs are exempted. That does not mean they do not fall under any regulation, but they are more prone than to be classified as a standard IP, because basically, if we are looking at them as pictures, they are sold as art, although they might have some specific attributes that make them classify as another financial instrument, for example. Here with NFT marketplaces, it's usually it's important to get the IP right. Meaning, if you have user-generated content on your platforms, you should get the proper license from the users so that you can use the art and you can sell it and you can profit on the trades that are made on your platform. This is one of the important steps. Another important step, if you are running an NFT marketplace or NFT generating platform, you should always also bear in mind that you should have some user guidelines, because as people are using internet is very very creative, you might run into issues with some with any topics that might be beyond the line. So you should be able to invoke some of your user guidelines and take the pictures down. For example, those are user generated, and you should somehow have power and some basic rules following which you have the right to monitor the platform. Then there might be another issue, and that is once you involve in higher value trades or fiat integration. Again, the KYC and AML rules might come in, although the NFTs, as we, at least in Europe, for example, where I provide services usually, are exempted from AML and KYC procedures. Although there are some exceptions naturally, but you can run such platform without the KYC and AML procedures kicks in. but you might have some monitoring obligations, for example. Then there's the third point is ensure IP compliance for artwork that should be tackled in the user guidelines or the code of conduct on your website, that each of the individual contributor, for example, should undertake that what they are posting to your platform is in compliance with every third-party IP. If not, that they can be held liable, for example, for uploading such image or whatever IP they are uploading. And then there is a set of standalone questions in relation to NFTs, and that is that different attributes of the NFTs might trigger different crypto or investment or financial regulations. For example, if you have fractionalized NFTs, it might jeopardize the non-fungibility, because when you have one NFT, when you mint one NFT with, I don't know, let's say an NBA star, for example, and you issue fractional shares, meaning 5 people own the very same NFT. Now each of their NFT becomes interchangeable, so it lacks the non-fungibility, meaning like not every NFT in such way is unique. So there are 5 NFTs, for example. Those are the very same, and thus they can be assessed as a security for token, for example. Then you should always check your marketing communication when it comes to NFTs, and you should always mark them as a piece of art and not as an investment opportunity, for example. So you should avoid saying that there might be some future gains or profits, or some annual staking reward, for example, for holding particular NFTs, because then it might be classified as a security token and not an NFT. Also, for example, you probably heard of Bored Ape Yacht Club, for example, which connects another feature to the NFT, meaning you can join some special club, you can go to some special events or restaurants, or any other service that is connected to the NFT. So the NFT might be classified as a utility token. And once we touch the utility token, for example, then it is considered a standard crypto service, meaning it might be connected. It might not fall under the exemption of the NFTs, which usually it is exempted from the crypto laws that are being adopted now. Also, another thing that comes to my mind is, for example, a fiat on-ramp or crypto on-ramp, then an exchange on your platform, and off-ramp in the other currency, for example. Because if I load, a lot of users can deposit fiat money to NFT platform, then they can buy some NFTs, do some trades, then sell the NFTs and withdraw crypto, for example. And in this case, your platform or this such NFT marketplace can be as an exchange in this case, which may again trigger some additional regulation. So either you can onboard again third-party service that will handle all of this for you, which is licensed, and this can help you avoid this such regulation, for example, and still provide the fiat and crypto on and off-ramp solutions for you. Macho, go ahead for the next.
You're moving on to tokenization platforms. There's not much different that hasn't been covered under both NFTs and DAOs, but I'm picking some of the specifics. So first of all, tokenization platforms are one of the most difficult Web3 business models in terms of regulation. So if you're thinking about tokenizing something, any kind of whether that's a physical good or like an investment instrument, could be anything. Do be prepared for relatively significant legal costs if you want to do this, of course, well and in a compliant way. So just raising this as a first red flag for this business model. It is complicated, but can be done well, of course. There's generally, your regulatory risk is usually tied to the asset that you are tokenizing. So usually most regulators don't care about whether you are selling your whatever asset that is as a physical asset or through a standard exchange or through it in a tokenized form. If the underlying asset is a share, for example, so a security, it being tokenized doesn't make it not be a security, not be a regulated instrument. Same goes for financial instruments within the EU or any kind of regulated assets and, real estate, for example. So do be careful about this and think about how the underlying asset could be regulated, who you could sell that to, and then of course you add in the another layer of tokenization. The regulatory frameworks that could apply here are quite varied. So of course, in the US, that would be the Securities Exchange Commission, because you'll be thinking about the tokens likely being securities if you're tokenizing, for example, shares in companies or shares in funds holding real estate or any form of financial instruments and derivatives. And then in the EU would have MiFID and MiCA. So there will be various regulations that you should look into alongside any sort of industry-specific regulation for the type of asset that you're tokenizing. The number one rule for maintaining security, both from the legal and sort of cybersecurity perspective, is nicely separating the issuer, so the company or the entity that creates the tokens that are being traded, the platform where the tokens can be traded. This is what they'll be offering. This is where the secondary market lives. And then the custodian, so the entity holding the asset that is being tokenized and preventing it from being sold in the off-chain world and being nicely tied to the tokens. And so this is like having to have this very clear separation and complexity makes it relatively difficult to establish clear ownership rights and really tie the tokens to the underlying instruments in a way that would be truly enforceable in court. So do be careful about this. Oftentimes we have very interesting business models related to tokenization, but they have to be done right and in a compliant way. Otherwise, they could end in a lot of issues. So, and then moving to DeFi protocols and DEXs. So the number one thing that we partly mentioned but I really want to stress here is that being a protocol neutrality or like completely decentralization is not a full legal shield for what you are doing. This is often what founders think, and they say, oh, hey, we're decentralized, so we're okay, right? No, if you're doing something, you're providing a decentralized service, it might be difficult to find who's responsible, but someone is almost always responsible until you are in one of those very sort of specific cases where you are the person who develops for example, the protocol, and then publishes it somewhere as open source and doesn't touch it afterwards. If you're not operating the protocol, if you have no control over the protocol, people can take it, run it in their infrastructure, it's run on sort of a decentralized network of the community, no one is governing it, you didn't have the stop button, you didn't control the website, the UX that would be tied to it. In that case, it's likely you could rely on many of the decentralization exemptions, but unless you're in this level of decentralization, it can be difficult. Often just having a nicely decentralized platform with decentralized governance, but having a front-end interface as a website and a platform that sort of lets people access the actual decentralized product can make you into a controller of the whole scheme and therefore the person who's responsible because you're doing the marketing. And without you running the interface, people couldn't easily it would be much more difficult for people to actually access the platform or the service behind it. So do be careful even about just running a front end for anything that is relatively decentralized otherwise. And this, of course, applies to all kinds of liquidity pool, staking or farming solutions. If people are putting in money and if anyone's funds are generally involved, then you're thinking about investment contracts, possibly securities, running an unlicensed investment fund. So if you are collecting money, do be especially careful. If you think you might be decentralized, you're likely not in that case. And then, of course, same goes for integration with third-party service providers. If you're working with any aggregators or maybe market makers, or anyone who's actively working on that, on your sort of in your protocol within your DEX and is influencing the flow of funds and tokens in there, you have to be careful about wash trading. You have to be careful about regulatory risk, user disclosures. Just as soon as you're working with someone else who's sort of influencing the protocol, has some level of control, a flag should be raised. You should consider what the possible exposure is. And then we're moving to sort of the final few practical lessons that we have learned, some of the mistakes that we have seen, things which you should take as the sort of unique pieces of learning that wouldn't necessarily be covered in sort of most of the structured things that we have covered so far. So first of all, what we have discovered is that even if you run most of your platform in a very decentralized way, if you're here talking specifically about DAOs first, if you're engaging with a team who needs to have contracts and might need to relocate somewhere because they might need, you all decide to meet in London, for example, for like a nice team offsite within sort of your management and development community, you often need an entity for this and have some sort of a legal wrapper because, for example, someone might need a visa invitation letter to get into the country. Or someone says, well, hey, I have to have an invoice, otherwise I'm technically committing a tax fraud in my country. So these are like all of those things where you suddenly need legal structure which you otherwise wouldn't expect. Same goes for defining any kind of rules and DAO constitution, which I think we'll provide a lot more details on this in the governance documents that we'll be sharing. But as we have seen too many projects where the structure was let's say too decentralized, too wild, too disorganized, and this led to very much internal conflict and chaos within the founding team. So do make sure that you set out your rules, just like we discussed with the policies in the beginning. And then finally, the point that I've already touched on, even if you're very decentralized, you could be liable. You're always responsible for your own actions. And we've had founders struggle with this to some extent because they've had a great, very complex decentralized structure, but then they personally did something that wasn't okay, that was, borderline attracted liability, and therefore they had to go through relatively unpleasant processes. And then I'll just provide a very brief summary here on the regulatory mapping. So we've had the entire first webinar talking about jurisdictions and how to choose them, but the three main questions that you should be thinking about here are where you're marketing or where you're servicing your users, because this is usually where jurisdiction will be triggered. Second, where your management team is located. Even if you're decentralized, you're providing services all over the world, a tax office might say, hey, all of your managers are based in somewhere in Singapore, for example, so we likely want to tax you in Singapore. So definitely be careful about this. And thirdly, think about the type of services your DAO will provide or the type of sort of utility to users, because some types of services provided by DAOs are highly regulated, others are not. Some are split by jurisdiction. So, do pick and choose what's relatively, easy and manageable for you. And then moving on to Andrej for the final examples.
And we will be tackling a crypto hedge fund. So we have a huge crypto hedge fund as our client that taught us a lot, because they were also evolving from basically doing high frequency trading. Then they onboarded an OTC desk and started to provide plethoras of other services. So the first question we were tackling is whether the fund will be serving retail or only experienced investors. That is, for example, a topic that further shapes the regulatory burden. If you are touching retail with any of your crypto services, it is always a higher regulatory burden. You might need to, it depends on when you are based, where you are based, and where you provide your services, and also where you market. But if you are providing services to retail, then you might need to prepare a lot more white papers and investment documents and notices to general public and so on and so forth, which will be very regulatory heavy and a huge burden even from the monetary perspective. But if you, for example, can close your project to be offered only to experienced investors, in that case, the threshold for the paperwork is much lower. So that is the thing that you can decide at the very beginning. Also, you can not be open to public, but you can do some clubhouse investing. There are rules for almost any type of investing, but it is always jurisdiction specific. And which jurisdiction is applicable here is considered under 3 rules. The first one is where you are incorporated, which is usually your first point of contact, because you will be reviewing your jurisdiction, whether you comply with laws, what are your obligations, and so on. But then once you establish your business and start provide services locally, that is okay. But with crypto, it is usually very quickly, it goes worldwide, because you want the crypto market is very decentralized and you want to touch as many customers as you can. And in that case, you should review at least the biggest market where your clients will come from. So because usually when we are talking financial regulation or the heavy crypto regulation, it is based on either where you are established, where are your customers, because the financial regulation usually protects the customers of its particular country. And the third one is marketing. And that is tied also to financial regulation laws. If you, for example, market to EU markets and you try to say like, okay, I market and target EU market, but I don't have many clients from there, it doesn't exempt you from the liability there, for example. And this is also applies for America and for Asia and African countries likewise. So that is like one of the points that you should focus on. Another point is the banking. If you are moving higher volumes of fiat money or crypto money, it is always a problem to open a bank account if you are a crypto business. We have mentioned this in the in the first webinar series. I have tackled this topic, and it is what our clients are facing a lot. And so the many projects are, as they are facing debanking and inability to maintain fiat accounts, you should consider stablecoin off-ramps and OTC counterparties, which will help you to breach these problems, for example, because usually the OTC desk have more lenient KYC and AML procedures against you as a client than the banks do. So you can consider this as well. And then there is also the standard multi-banking strategy, meaning you don't only have one bank account, but you have several of these, and you may try to send. If you can stay on chain, that is perfect for you, because there it is usually smooth. But when you want to go on any off ramp, then the hurdles start. And also bear in mind that crypto and fiat conversion remain a compliance risk, because it might trigger financial or the more heavier crypto regulation. So once you onboard your clients with fiat, for example, you should also offboard them with fiat money. Next one, please, Maciej. And this is what we have run through with our clients. With this crypto hedge fund, there are a lot of going on, and these are all separate topics. These are just a few notes that you can bear in mind. If you are doing crypto trading business, you should always have clear agreements and understanding in your trading agreements, outlining the fees, the spreads, and custody, because the custody is usually the thing that might trigger your regulatory liability. So you can even you can cover this in the agreements. For example, if you don't have the custody of any client's funds, for example, then you should make clear it stays like that even in the agreements, because you might then trigger the higher regulation for yourself. Then there is the non-circumvention clauses to protect business relationships. It happened to our clients where they, for example, had their OTC clients which they served and they started with, but actually throughout the time they were ouched by the counterparties, for example, which imposed a huge problem. So you should have such clauses involved, and in that case, you can legally follow the liability. Then there is the termination and liability clauses for sudden liquidity and shifts in volatility. Liquidity shifts and volatility, meaning there might be some issues when you are, for example, providing some thresholds that you have to meet, but the sudden liquidity shifts might trigger some other cascade effects. For example, your collateral might get liquidated and so on and so forth. So you should always bear in mind that these things in crypto might happen, and you should have them covered in the contract. And also what you can do is, if you are setting up some thresholds, try to tie them to main 3 or 4 exchanges, because even if one has some outage or whatever, it might be still within the boundaries if the other 3 exchanges are working normally. And the last one is the AML obligations when acting as an agent. So even though you are providing services and you have some regulatory memo from your lawyers that you are providing business such and such, and in that case you are not regulated, it might happen then that through contracts with third parties, you will shift this regulatory analysis in such a way, and you will provide your services in such a way that you might trigger some regulatory burden. For example, you will be getting clients' money and trade with them, but you should not structure it such. You should structure it such that you are not getting the money from the third-party services, the client's money, but you are mainly, for example, buying some futures and then executing these futures for your counterparty, not for the clients, for example, and so on and so forth. There are a lot of things really to tackle here, and we don't have that much time here. It is just some few examples that you should bear in mind. And I believe that's it. So let's wrap it up. There are a lot of things to consider. I would start from the least important, and that is the privacy policy and the product not related things. That is basically the privacy policy and cookie policies that I spoke about. But then when you touch the product, you should be more concerned. For example, the terms and conditions you should have ready from day one, because it is the core of your business. Also, regulatory analysis, the more you can get general feeling whether you are dealing with clients' funds or not. The more you are touching the client's funds, the more regulatory burden there is. So you should always tackle this as a priority. If you are being more decentralized, then you should always do the evaluation, but you should focus on your product first, for example. Also, always have in mind that each crypto sector has its unique legal risks, so you should tackle these one by one. Then another thing, compliance depends not only on your product, but also where and how it is offered. That is the part about the marketing and when you are based. So at the very beginning of your product journey, you will be under scrutiny of your jurisdiction of incorporation regulators. But if you grow bigger, you might be regulated also by other jurisdictions, and other regulators might investigate you, for example. But you should prepare for this beforehand, at least for the main jurisdictions where there are higher probability that you will be reviewed. And the last point is that the case studies show the need for legal structuring, which you should always plan ahead, and you should do your own research first, and then consult professionals. And you should always plan ahead. Once you have the product and you are ready to launch, then at that stage you should focus on investments and on legal issues. Matteo, feel free to add anything.
We're running over slightly, so the only thing I'll add is really thank you for spending the time with us. Sorry for running over a couple of minutes. I do hope that you took over something from this. We are available. Do reach out to us if you have any questions. And of course, we're uploading this to YouTube. So if there's anything that you didn't catch that you wanted to go through again, you'll be able to look at this and just look through the specific slides. Okay.
Perfect. We still have we have just one question from the public, and it is Marcus Bani is asking whether he should or she should send a white paper 4 to 6 weeks in advance of its publication on the website to the domestic financial authority versus publication on day one. So it depends on your country mainly, but if you are seriously regulated, then I would consult the financial authority beforehand. Then it depends from state to state, but basically, if you have the obligation to be in compliance, you have two ways. Either you must send it beforehand, which is quite usual to get an approval, or you might not need to do this beforehand. And if you don't need to do this, and then you have the option also not to consult with the financial authority, because if you consult, then you will naturally get a reply, and it might not always be the reply that you want. So it depends on what you are seeking. If you have the obligation to consult, then I would do it beforehand with more time prior to the publication date, because then you can tweak it. But if you send it to the regulator for review on day one of its public publication, it might happen that they will have some objections, and you might have a problem because you are already providing services which are not in compliance with financial regulation. If there is any other question, we are still here to answer, or you can reach out to us at our emails that are on the screen currently. Okay, we got a reply that that the country is Germany, and whether it's heavy regulated, it really depends. It's hard to say from scratch, like what are you providing? But yes, Germany is usually a well-regulated country.
And if your service is covered on the MiCA, then you might have the obligation to actually send in things before you provide anything in certain cases, and do plan for a much longer review period, especially if the regulators are now quite on the heavy fire and there's lots of people applying for licenses, so it might take them quite a while to process things.
As you touched this topic, we will actually have a 3-part series on the MiCA regulation as a main European regulation, being also a framework that will be probably applied in some ways in other jurisdictions as well, and that will start in 2 weeks on Wednesday. I will update the channel as I was updating about these sessions. And also in MiCA, just to answer the question fully, although they have these 30 days or 60 days for some of the reviews, it might get longer, not on their side. They will probably keep their deadlines, but they will ask for a lot of supporting documents, which will prolong the whole process actually on your side, and that is definitely inevitable if you are doing a licensing procedures. And we are also doing these MiCA licensing procedures. We have established connections with the national banks throughout Europe. Definitely not in all jurisdictions, but in some of these. And if you are applying for a MiCA license, for example, it is passportable throughout whole Europe. So you need to get one license in any of the country, and then you can basically very easily provide services anywhere else. So yeah, I didn't particularly answer your question, but it's like it's not possible.
We'll provide a lot more details on this in the MICA webinars.
Okay, then thank you everyone